An act to amend the law relating to the transfer of property by active parties. Preamble. Whereas it is expedient to define and amend certain parts of the law relating to the transfer of property by active parties, it is hereby enacted as follows. Chapter 1. Preliminary. 1. Short title, Commencement, Extent. This act may be called the Transfer of Property Act, 1882. It shall come into force on the first day of July, 1882. This act or any part thereof may by notification in the official gazette be extended to the whole or any part of by the provincial government, and any may, from time to time, by notification in the exempt either retrospectively, prospectively, and part of the territories administered by such provincial government from all or any of the following provisions, namely, Section 54, paragraphs 2 and 3, 59, 107 and 123. Notwithstanding anything in the foregoing part of this section, Section 54, paragraphs 2 and 3, 59, 107 and 123 shall not extend or be extended to any district or tract of country for the time being excluded from the operation of the Registration Act under the power conferred by the first section of that act or otherwise. 2. Repeal of acts, saving of certain enactments, incidents, rights, liabilities, etc. in the territories to which this act extends for the time being the enactments specified in the schedule hereto annexed shall be repealed to the extent therein mentioned, but nothing herein contained shall be deemed to affect the provisions of any enactment not hereby expressly repealed. Any terms or incidents of any contract or constitution of property which are consistent with the provisions of this act and are allowed by the law for the time being in force. Any right or liability arising out of a legal relation constituted before this act comes into force, or any relief in respect of any such right or liability, or save as provided by Section 57 and Chapter IV of this act. Any transfer by operation of law or by or in execution of a decree or order of a court of competent jurisdiction, and nothing in the second chapter of this act shall be deemed to affect any rule of law. 3. Interpretation clause. In this act, unless there is something repugnant in the subject or context, immovable property does not include standing timber, growing crops or grass. Instrument means a non-testamentary instrument. Attested, in relation to an instrument, means and shall be deemed always to have meant attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has seen some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal acknowledgement or his signature or mark, or of the signature of such other person, and each of whom has signed the instrument in the presence of the executant. But it shall not be necessary that more than one of such witnesses shall have been present at the same time, and no particular form of attestation shall be necessary. Registered means registered in under the law for the time being in force regulating the registration of documents. Attached to the earth means rooted in the earth, as in the case of trees and shrubs. Embedded in the earth, as in the case of walls or buildings, or attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. Actionable claim means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of movable property, or to any beneficial interest in movable property not in the possession, either actual or constructive, of the claimant, which the civil courts recognize as affording grounds for relief, whether such debt or beneficial interest be existent, accruing, conditional, or contingent. A person is said to have notice of a fact when he actually knows that fact, or when but for willful abstention from an inquiry or search, which he ought to have made, or gross negligence, he would have known it. Explanation 1. Where any transaction relating to immovable property is required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of, or share or interest in, such property shall be deemed to have notice of such instrument as from the date of registration, or, where the property is not all situated in one sub-district, or where the registered instrument has been registered under subsection of Section 30 of the Registration Act, 1908, from the earliest date on which any memorandum of such registered instrument has been filed by any sub-registrar within the sub-district, any part of the property which is being acquired, or of the property wherein a share or interest is being acquired, is situated, provided that the instrument has been registered and its registration completed in the manner prescribed by the Registration Act, 1908, and the rules made thereunder. The instrument has been duly entered or filed, as the case may be, in books kept under Section 51 of that Act, and the particulars regarding the transaction to which instrument